So when can the police search without a warrant? Certainly with the person's consent. And that can get confusing. Sometimes more than one person has the power to consent. For example, roommates in an apartment, a couple that owns a house together, a parent of a child, a renter who is renting the apartment and the landlord, sometimes, depending on circumstances, guests in a hotel and the owner of the hotel. When it's necessary to protect the officer's safety, sometimes known as a stop and frisk, when police are questioning a person who is not yet seized, but they want to make sure the person isn't armed. That's the Terry versus Ohio case. It's called a Terry search. When you've already been seized based on valid grounds for seizure, then the police can search you, your belongings, your purse, your backpack, your car, but almost certainly not your house without a separate warrant. This is known as a search incident to arrest or an inventory search. Examples: police tow your car to the police department lot after they've arrested you. They can look all over the car, even the trunk and the glove box. Police can empty your pockets when they take you to the jail. They can also search without a warrant when evidence is in plain view, so that it is immediately obvious what it is. For instance, a transparent plastic bag of drugs that a person leaves sitting on the passenger seat of his car. They can search without a warrant when there are what are called exigent circumstances. Sometimes the law recognizes that the police have to make snap decisions because the decision is so urgent or so time sensitive. Examples: the evidence is about to be destroyed, or in hot pursuit. If a suspect is being chased, runs into an apartment, slams the door, the police don't have to wait outside until they get a court order. They just have to announce that they're police and knock it down. Okay? The court really tries to attempt to protect a reasonable expectation of privacy, so keep that in mind. I'm going to mention one thing. There are other search warrant exceptions. There's a link on the PowerPoint. You can take a look at those. I am going to mention one other thing about confessions and self-incrimination. We've talked about the Miranda case. You need to know the Miranda case for this test. A confession is presumed to be involuntary unless the suspect fully is informed of their rights. The protection does not apply if, while in jail, a suspect confesses a crime to another inmate who turns out to be an undercover officer. Okay. The constitutional ban originally was intended to prevent torture or coercion, and we've seen in the recent court cases that the Miranda rules are being relaxed a little bit to give the police more leverage. The information on national security and right to privacy, on the war on terrorism and civil liberties, is not on this test. You will be receiving an assignment on this for next Friday. But I want to go ahead and mention it to you right now. The USA Patriot Act, meant to increase federal government's powers to combat terrorism. The government may tap any telephone used by a suspect rather than obtaining a separate order for each phone. They may tap with a court order internet communications. They may seize with a court order voicemail. Investigators can share information learned in grand jury proceedings. Any non-citizen may be held as a security risk for 7 days, longer if certified to be a security risk. Federal government can track money across U.S. borders and among banks, and the statute of limitations on terrorist crimes has been eliminated and penalties increased. There was an executive order, that proclaims, if there is an executive order proclaiming a national emergency, a non-citizen is believed to be a terrorist or to have harbored a terrorist, that individual may be tried. Initially, that individual was believed that it could be tried in a military court. However, there are a couple cases in your book that have stopped that. The Hamdi case, is in your book. It is in the landmark cases. The Hamdi case, you ought to take a look at the Hamdi case. all right, effectively, which declares use of military proceedings, military tribunals set up by the Bush executive order unconstitutional, because even if they are considered quote-unquote enemy combatants, they still must be given unlawful combatants, which is a term that is not in the Geneva Convention and came up during the Bush administration. They still must be tried and given due process like anybody else. Recently, President Obama has ordered the closing of Guantanamo Bay. The problem is what to do with the inmates. 50 remain in the prison, and there's no country willing to take them. The Patriot Act was renewed in 2006, and almost all of the provisions were made permanent. We also have an Identification Act, which applies to the states and requires all states to comply with federal standards when issuing driver's licenses. Warrantless telephone taps are allowed for foreign spies, okay, but those have been limited. In 2008, Congress passed a bill allowing the government to intercept foreign communications with people in the United States with the approval of the FISA court. Private and internet companies that aided in this were exempted from lawsuits so long as they received substantial evidence that the program was authorized by the president. Okay, so it can exempt the internet company for opening up their records. All right. Should the exclusionary rule be absolute? In recent years, the Supreme Court has allowed a number of exceptions to the exclusionary rule. They are been discussed in your textbook. Should the president be able to suspend civil liberties for terror suspects? In the aftermath of September 11th, the government's response to the terror attacks reveals a tension between the preservation of national security and the preservation of fundamental civil liberties. I think for your own sake, you should take a look at some recent current event articles that have to do with the Bush administration and their use of torture at Guantanamo Bay and other prisons, and how that's a violation of the Geneva Convention. It is a violation of an expectation of privacy. It is a violation of human rights, which we effectively signed, all right, with the United Nations, and makes our country look a little less than what it should. We will talk more about this after you look at sections of the Patriot Act on Friday. The issue of right to privacy is at the end of this PowerPoint. It's right here. It has to do with the Ninth Amendment. We'll talk about the Ninth Amendment, Griswold, Roe versus Wade, at the very beginning of, and partial birth abortion, at the very beginning of the section on Chapter 3 on federalism. We'll stick it in at that point.